system accurately deliver justice if it clings too tightly to the past? Or can it remain reliable if it changes too easily? Hello everyone, my name is Manali Nav and today we will examine a key principle within the English law, the doctrine of judicial precedent, and consider to what extent it promotes both consistency and flexibility within the legal system. We will outline the structure and hierarchy of the courts, examine the distinction between ratio decidendi and obiter dicta, explore how distinguishing, overruling and reversing allows the law to adapt, analyze the impact of landmark cases on the development of common law, and finally, we will evaluate the tension between legal certainty and the need for adaptability. So let's begin.
Hello everyone, my name is Amy. Today I'll be presenting the structure and hierarchy of the English courts in relation to judicial precedents. A clear court hierarchy is essential because it ensures consistency in how laws are applied. In England, the court structure differs between civil and criminal matters because they serve different purposes. Civil law deals with disputes between individuals, while criminal law addresses offenses against the state. Understanding where the court sits in hierarchy is key to understand how precedent works. Let's start with the civil courts. At the bottom, we have the county court, which handles first instance cases like contract disputes, torts, and personal injury claims. It does not create binding precedent, but it must follow decisions from higher courts like the High Court, the Court of Appeal, and the Supreme Court. Next, the High Court is divided into three parts. First is the Queen's Bench divisions, which is deal with contract and tort cases. Second is the Chancery divisions, handles issues like trusts, patents, and mortgages. And the third division is the Family division, deals with family disputes. The High Court can create precedent for lower courts, but must itself follow decisions from the Court of Appeal and the Supreme Court. Then we have the Court of Appeal of Civil Divisions. This court hears appeals from the High Court and certain tribunals. It binds all lower civil courts. According to the case Yan and Bristol Aeroplane, it is usually bound by its own past decisions, except in three cases: when early decisions conflict, when the Supreme Court has ruled differently, or when a decision was made by a serious legal error. Now let's move on to criminal courts. The magistrate courts handle summary and some either way offenses. It does not create precedent and must follow decisions of higher courts. Above that is the Crown Court, which deals with serious indictable offenses and appeals from magistrate courts. Like the magistrate courts, it does not create precedents, but must follow rulings from above. The High Court, also can call Queen Bench Divisional Court, hears appeals and reviews from the magistrate courts. Its decisions are binding on magistrate court, but not strictly binding on Crown Court. And the second court is the Court of Appeal of Criminal Division, is just below the Supreme Court. It hears appeals from the High Court and binds all lower criminal courts. It generally follows its own past rulings but can depart in special situations to avoid injustice. At the top is the Supreme Court, which is the final court of appeal for both civil and criminal cases in the UK, that binds all other courts and can overrule its own previous decisions using the 1966 practice statements. This allows it to correct outdated or unjust rulings when necessary. And now I'm gonna explain about how the Court of Justice of the European Union, also means CJEU, relates to judicial precedent and court hierarchy. Before British access, UK courts could refer questions on EU law to the Court of Justice of the European Union under Article 267 TFEU, which stands for the Treaty on the Functioning of the European Union. CJEU decisions were binding in areas of EU law, even though it wasn't part of the UK court structure. After British access, referrals are no longer allowed. However, UK courts are still bound by retained EU law, that is, CJEU rulings made before the end of 2020. Only the Supreme Court and the Court of Appeal can depart from this, and only in limited cases.
Hello guys, my name is Ainin, and I'm going to talk about ratio decidendi and obiter dicta. let's talk about ratio decidendi. It is a Latin term meaning the reason for deciding. It is the legal principle that a judge used to reach the decision based on the key facts of the case. This ratio becomes binding precedent, which lower courts must follow it in future similar cases. Now, one of the most famous examples is Donoghue and Stevenson, 1932. Here, Mrs. Donoghue drank ginger beer containing a decomposed snail and fell ill, even though she had not bought the drink herself. The legal issue was, did the manufacturer owe her a duty of care? Lord Atkins said yes, because you must take reasonable care not to harm your neighbor, meaning anyone closely affected by your actions. That neighbor principle is the ratio, and it created the foundation of modern negligence law. So, how does ratio decidendi promote consistency? It gives a clear rule for courts to apply in the future cases, which help build a predictable legal system. But it also allows for flexibility. Take the recent case of Robinson and Chief Constable of West Yorkshire, 2018. An elderly woman was injured during a police arrest on a crowded street. The Supreme Court said the police did owe her a duty of care because it was foreseeable that their action could cause harm. That decision didn't break from Donoghue, it built on it, adapting the principle to modern situations. So, ratio decidendi is a key. It keeps the law stable and consistent while letting it grow to meet new challenges. Now, let's talk about obiter dicta. It's a Latin for things said by the way. These are parts of a judge's reasoning that are not essential to the decision. They might include comments on hypothetical situations or broader legal suggestions. They are not binding, but they can be highly persuasive, especially if they come from higher courts like the Supreme Court. Take the case of Ironhoe, 1987. The House of Lords ruled that duress is not a defense to murder. That was the binding ratio decidendi. But then, the judge went further. They said duress should not be a defense to attempted murder either, even though that was not the issue in the case. That was obiter dicta. And it didn't end there. In R.N. Gotts, 1992, the courts actually used that obiter as a guide and formally adopted it. So, what was once just a comment became part of the law, showing how obiter can guide future development and promote flexibility. Another great example is Central London Property Trust and High Trees House, 1947. During World War II, a landlord agreed to reduce rent. After the war, he tried to claim it all back. Lord Denning said, no, the tenant relied on that promise. But in obiter, Denning went further, suggesting that a promise might be enforceable without consideration if someone relies on it. That idea later become the doctrine of promissory estoppel used in future cases like Combe and Combe. So, obiter dicta may not be law today, but it often becomes law tomorrow. It gives judge the space to explore, suggest, and shape the future, making precedent not just consistent but adaptable and forward-looking.
How do judges develop precedents? Or how do judges avoid following an earlier decision? Precedents can be avoided using the three concepts: distinguishing, overruling, and reversing. First, let's jump into distinguishing. Distinguishing is a method used by the lower courts to avoid following a past decision. Lower courts are bound by the higher court's decision, but in a situation where there is a significant difference in the material facts of the original case and the case being considered, the lower courts may avoid using the binding precedent established by the higher courts. The judge is able to distinguish a new case from the previous ones, hence the binding precedent is not followed. One of the examples is when the court was able to distinguish between Balfour v. Balfour from the case of Merritt v. Merritt. There is a rebuttable presumption that agreements made in social and domestic contexts have no intention to create legal relations. In Balfour v. Balfour, the husband promised his wife certain sum of money. After the separation, the husband stopped the payments. As a result, the wife sued him for breach of contract. The court ruled there was no intention to create legal relations between the two parties. However, this presumption was rebutted in the case of Married We Married, when the husband promised during the breakup of the marriage to his wife full entitlement of the matrimonial house if the wife would pay off the mortgage loan. The husband refused to abide by his word, and the issue was brought to the court, where they were able to distinguish this case with Balfour v. Balfour, coming with a different judgment. As in Married We Married, the promise was made when the couple were living in amity, meaning the marriage was on point of divorce. But in Balfour v. Balfour, the promise was made when the couple were on good terms. Hence, it was held in Married We Married, there was intention to create legal relation between the husband and wife. Moving on to overruling. Overruling occurs when the superior courts decide against the judgment of the lower courts. In other words, they depart from the earlier precedent established by the lower courts in a different case but with similar material facts. This means the superior court holds the authority to overrule precedents as they are not bound by the previous precedents settled by the lower courts. As a result, the new ratio decidendi from the latest case becomes a binding precedent to be followed by all the lower courts in the future. To add on, the House of Lords also have the right to overrule its own previous decisions. In the case of RVR, during the separation of the defendant and wife, the defendant attempted to force himself onto the wife without her consent. The House of Lords overruled the common law rule which stated marital rape was not a crime and hence the husband could not rape his wife as the contract of marriage gave irrevocable consent. And lastly, reversing. Reversing occurs when the higher court succeeds to identify the law wrongly interpreted by the lower court and proceeds to retract the decision of the lower court on appeal of the same case.
Give me your stuff or else.
A little background of what's happening here. The man was found guilty after robbing his boss's house and pretended to be armed. The defendant, in an attempt to intimidate, placed his hand inside his jacket and pointed his finger to mimic a firearm. Although no actual weapon was found, both the Crown Court and Court of Appeal held him guilty under Section 17 Sub 2 of the Firearms Act 1968, which highlights possession of a firearm or imitation firearm during the commission of an offence. In today's hearing, we will finally get to know whether the House of Lords will deem him guilty or reverse the decision. So the House of Lords has given the construction of Section 17 Sub 2 plain and ordinary meaning, stating that he must be in possession of a firearm or imitation firearm in order to be deemed guilty. But in this case, he was not in possession of any firearm, he was only pointing his finger. Interpreting the Firearms Act 1968, Section 17 Sub 2, the House of Lords found that he was not guilty and subsequently reversed the decision of the Crown Court and the Court of Appeal. Thank you guys.
A landmark case is a case in which the decision made by a superior court establishes a new legal principle that significantly changes the interpretation of existing law. It creates a precedent and shapes how future cases are decided. These cases play a very crucial role in the development of common law as they set new legal rules and change how existing laws are interpreted. These cases usually come from superior courts like the Court of Appeal or the Supreme Court. Landmark decisions usually become a precedent and future judges in lower courts follow it when dealing with similar situations. A good example of a landmark case would be Donoghue vs. Stevenson. In this case, Mrs. Donoghue fell ill after drinking a ginger beer that had a dead snail inside it. The drink was bought for her by a friend, so she could not sue under contract law as she didn't enter into a contract to purchase that ginger beer. The court decided that the manufacturer owed her a duty of care, and this case created the modern law of negligence and also introduced the neighbour principle to determine whether a duty of care is owed. A neighbour are people that you can reasonably foresee that will be affected by your actions. This became a key precedent in English common law, and it is still used in courts today. Another example of a landmark case would be R vs. R. In this case, a husband was charged with raping his wife while they were married but were not living together. Before this case, the law stated that a husband could not be guilty of raping his wife because of a rule that marriage gave permanent consent. However, the court in this case decided that the rule was outdated and unfair to the parties of the marriage. So the judges ruled that a husband can be guilty of rape against his wife. This case overruled the old common law rule, and it showed how courts can change the law to reflect modern values and protect victims. Landmark cases like this show how judges use reasoning to make the law fair and more modern. They help the legal system stay consistent and up to date, but also making it flexible enough when necessary changes need to be made. In conclusion, landmark cases are key reasons why the English common law continues to grow and stay relevant in society that is changing swiftly.
Hi everyone, I'm Lakshmi Nimeta, and I'll be discussing on the establishment on how the judicial president operates and its significance in ensuring legal certainty. Legal certainty plays a significant role in legal relations, regulation of individuals' behaviors, and to promote stability. It also enables the judiciary to provide fairness, uniformity, predictability, and confidence amongst individuals in preparing their legal suits. Hence, flexibility in law is important to enable the law to evolve and adapt to social changes. Law evolution refers to law developments or responses to suit the societal, economic, and technological changes according to latest developments or challenges. Nevertheless, globally, there has been a challenge in striking the balance between having legal clarity and the law evolution. Hence, it is significant to explore into the necessity and mechanisms that may assist to strike a balance between legal certainty and legal evolution while applying the doctrine of judicial president. However, this would require a careful scrutiny for the reasons discussed hereafter. Even though legal clarity is significant for the reasons mentioned above, the absence of legal evolution may render the present laws to be redundant, outdated, and fail to resolve disputes effectively. This may lead to injustice. It is important to have sets of laws that evolve to maintain social order and regulate human behavior according to the societal changes and challenges at present. At the same time, prioritizing law evolution at all times may also jeopardize legal certainty, and this may result in uncertainty of law amongst individuals and undermine the legitimacy of present legal framework. The question that arises is what are the mechanisms that may be adopted to balance legal certainty and the need for law evolution? Firstly, the doctrine of judicial president is not absolute and it can be practiced with flexibility. When a higher court's decision is erroneous or per incuriam, the court may depart from its own earlier decision. Ince J. and Habib Morton and Transvaal government acknowledged as follows. It is lesser evil for a court to override its own legal opinion, clearly shown to be wrong, than indefinitely to perpetuate its error. Hence, one mechanism to strike balance between legal certainty and the evolution of law is by the higher courts having discretion to discern from its own previous decisions, either when there was error in the earlier decision or when the said decision does not fit into the societal changes now. This will render the law to evolve while practicing doctrine of president with flexibility to fit into the current societal changes. Besides doctrine of president, when practiced with flexibility, enables errors in previous decisions to be corrected and uphold the legal development in accordance with constitutional provisions. However, as highlighted earlier, in order to ensure that the law evolution is not overly prioritized to the extent of jeopardizing legal certainty, the flexibility in practicing judicial president must be done transparently and with proper legal reasonings by the judges when they discern from their earlier decisions. This is to enable legal clarity and law evolution to develop in parallel. Secondly, exercising of discretion by judges to interpret laws will also contribute in legal evolution. Even though ordinary words are given ordinary meanings, legal provisions frequently require interpretations as the meanings of legal terms may be open to various interpretations. Often legal terms in legislations are ambiguous and require judges to exercise their discretion to interpret the provisions by looking into Parliament's intention when passing the bills. Besides, the Parliament would not have foreseen every aspect of societal changes when drafting the laws, and hence the probability of having gaps in the legal framework exists. Therefore, it is vital for the judges to exercise their discretion to refine and update the legal frameworks by interpreting the provisions to adapt to the changing social norms or social evolution. In conclusion, there is a need to balance between legal clarity and law evolution while practicing the doctrine of judicial precedent. Nevertheless, even this balancing must be done with scrutiny and carefully so that the law evolution does not overtake legal clarity and vice versa, as this may lead to adverse impacts discussed above.
Hi, today our group will be presenting on the topic to what extent does the doctrine of judicial precedence promote consistency and flexibility in the English legal system. Judicial precedent is one of the core principles of English common law. It means that judges are guided by the decisions made in previous similar cases. This promotes fairness and predictability, but it also allows the law to evolve and adapt when needed. In this presentation, we will look at how precedent achieves that balance. So, we will be covering how consistency is maintained, how courts are structured, how legal reasoning works, and how landmark cases shape future decisions. So, to begin, I'll be explaining how judicial precedence promotes consistency in the legal system. What is judicial precedence? Judicial precedence, also known as the Latin term stare decisis, means to stand by things decided. This principle ensures that once a legal rule has been established in a case, future courts must apply the same principle when dealing with similar facts. This creates a legal system that is not random but instead built on logic, stability, and consistency. The English court system is built on a clear hierarchy, and this hierarchy reinforces consistency. Decisions made by higher courts like the Supreme Court or Court of Appeal are binding on all lower courts. This means that a principle laid out by the Supreme Court must be followed by courts such as the High Court or County Court, even if the judges below disagree with it. This structure ensures that like cases are treated alike, no matter where they are heard or who the judge is. Another way consistency is promoted is through something called ratio decidendi, which means the reason for deciding. It refers to the legal principle that the judge used to reach their decision. This part of the judgment is binding on future cases and forms the foundation of the case law. A classic example is Donoghue and Stevenson, where the court said that manufacturers owe a duty of care to consumers. That principle, the ratio, has been followed in thousands of negligent cases ever since. Because of ratio decidendi, future judges know exactly what rule to apply, leading to uniform and predictable outcomes. This kind of consistency provides legal certainty. For instance, lawyers can predict the likely outcome of a case and give reliable advice. Individuals know what to expect when they go to court. Businesses can make informed decisions based on stable legal rules. This consistency also strengthens public confidence in the justice system. When people see that the same rules are applied fairly, it builds trust in the courts and the rule of law. Of course, no system is completely rigid. There are exceptions such as distinguishing cases or overruling old decisions, but these are carefully controlled and will be explained later in the presentation by my teammate Masha. The key point is, judicial precedence promotes consistency to a large extent, even while allowing some space for development. To summarize, judicial precedence promotes consistency by three items. Firstly, following established rules, stare decisis. Second, applying binding legal principles, ratio decidendi, and maintaining a structured court hierarchy. This consistency ensures fairness, predictability, and trust in the legal system. Thank you.
Thank you, Joy. I'm Marsha, and I'll be discussing on the doctrine of judicial precedence and how it promotes flexibility in the English legal system, and how that said flexibility helps the law to stay relevant today. We often think of precedence as promoting consistency, but that alone is not enough. The law has to be applicable to real life, and that means to adapt to facts, to new values, and to the ever-changing societal norms and values. That is where flexibility matters. We'll start with distinguishing. Distinguishing is when the court avoid applying a past decision on a new case because the facts are materially different. For example, in Merritt against Merritt, the court distinguished it from Balfour against Balfour, even though both cases are about agreements between spouses. Reason why is in Merritt, the agreement was made in good terms and it was made after the separation, so the court treated it as legally binding. So this shows that precedent is flexible enough to be applied in real-life situations. Another example is overruling. This is when a higher court changes the legal rules set in a past decision. For example, in R against R, the court overruled the old idea that a husband cannot be liable for raping his wife. The court said that this idea is outdated and no longer reflects the modern society's values. So this shows that precedent is flexible to adapt as time changes and how the society's values change. Another one is reversing. This is when a higher court disagrees with the lower court's decision on a case and decide to change the outcome of the case. So even though reversing doesn't create a new rule like overruling does, it shows that the court has a way of correcting what they see as misinterpretations of the law. And the biggest step, I would say, towards flexibility in the English legal system is the Practice Statement 1966. Prior to this, the House of Lords were bound by its past decisions, even if it was outdated. But the Practice Statement states that the court may depart from its past decisions, and I quote, when it appears right to do so. So this gives room to the judges to fix rulings that are unjust or unequitable without having to wait for the parliament to be involved, to step in, because that is a very, very lengthy process. Even the Court of Appeal, which is usually bound by its own past decisions, has its own exceptions under Young against Bristol Airplane. And these exceptions include when there are two conflicting decisions, when a later Supreme Court overrules the decision, or if the decision was made without considering an important law. And these exceptions help the court to stop itself from repeating mistakes. And legal scholars back this idea of controlled flexibility. For example, Sebastian Lewis, in his 2021 article, Precedent and the Rule of Law, says that flexibility isn't just useful, it is essential. And he says that the English legal system must be able to correct itself while still giving people clarity as well as fairness. And Joseph Raz, a leading legal theorist, says that the rule of law must still give people stability and as well as change, because a rule, a legal rule or law that doesn't change or never changes can become unfair. But here's the risk. If precedent becomes too flexible, then no one knows what the law actually is, and this risks legal certainty as well as the public's trust on the justice system. So the system overall has to strike a perfect balance between the two. So in conclusion, the doctrine of judicial precedent promotes flexibility to a large extent through the mechanisms I've mentioned. And these tools help the law to move forward while still maintaining structure as well as fairness. And as someone who studied these legal rules and laws in depth, I would argue this. The real strength of judicial precedent isn't in just following the past. It's actually when and knowing when to let it go. Thank you.